In this video, we cover the role of the executor in the filing process. The responsibilities of the executor. The duties of the executor or the personal representative include obtaining an estate EIN. The executor is technically responsible for this. Of course, the executor can hire an accountant or a lawyer to do it for them, but this is the responsibility of the executor, is to obtain an estate EIN. To file Form 56, Notice Concerning Fiduciary Relationship. This form is similar to the Form 2848, which is the IRS Power of Attorney, except this is basically the notice to the IRS that you are the executor. You're going to be the fiduciary or the executor of this estate. This form basically notifies the IRS of your position as the executor. The executor is responsible for distributing estate assets according to the decedent's wishes, basically as outlined in the decedent's will. If the decedent doesn't have a will, then the executor is going to be responsible for distributing the assets according to state law. They have to sign the appropriate line of each of the following tax returns that may need to be filed. Sometimes a taxpayer will die and they don't have to file any of these. Sometimes a taxpayer will die and they will have to file all of them. It all depends on the facts and circumstances. But generally, the more valuable the estate is and the wealthier the person is when they die, the more likely it is that all of these will have to be filed. The final income tax return for the decedent. This is the Form 1040 for the income received before death. And many times, especially if a person has been ill for a very long time, they have Alzheimer's, or they have cancer, sometimes the executor will be forced to file multiple years of delinquent returns. And if those are filed late, because the court process is taking a long time, sometimes it will take months and months for the personal representative or the executor to be named, because these things don't happen overnight, and many times the courts are backed up. Sometimes the executor will be forced to file multiple years of delinquent tax returns. And if they are delinquent, if they're very late, then many times they cannot be e-filed, because eventually the Social Security Administration will turn off, or whatever they do, they turn off the Social Security number. So many times these have to go in on paper, which means they have to be signed by the executor and mailed in and signed with a wet signature, which means they have to be signed with ink. The executor signs it, and I'm going to show you what it looks like on the tax return when you have to do this. But many times you will have to do this. You will have to actually print out the tax return and mail it in if it has to be signed by an executor. The executor is also responsible for filing the fiduciary income tax returns. This is the Form 1041 for the estate for the period of its administration. As long as the estate holds assets that have not been distributed to the beneficiaries of the estate, then the estate is going through its period of administration. And then the estate tax return, which is the Form 706. The Form 1041 is filed on an ongoing basis until the estate is closed. The Form 1041 is filed every single year, basically that the estate is earning income. The Form 706 is a one-time deal. The Form 706, the estate tax return for the estate tax, which is not an income tax, this is filed only once. And I want you to remember this form number, the Form 706. The Form 706. It's not the Form 709. The Form 709 is for gifts. Gifts are something that you give while you're alive. The Form 706 is for the estate tax return that reports the value of the decedent's estate when the assets pass to the estate after death. Form 706. And the way that I want you to remember it is the Form 706 is for 6 feet under. It's a very common phrase in English. 6 feet under means you're 6 feet under the dirt. That means you're dead. 6 feet under. The Form 706 is the estate. If you're 6 feet under, that's when you have to file the Form 706. 709 is for gifts. That's for a person who's alive. Okay? The personal representative is responsible for determining any estate tax liability before the estate's assets are distributed to the beneficiaries. Now, I want you to understand that you don't have to ever be an executor for an estate. Someone could name you their executor in their will. You don't have to do it. Nobody can force you to work. Nobody can force you to be an executor. You can walk away from it and you can say, no, I don't want to do this. Just realize that if it's a situation where you have been named executor and you don't want to do it, then you're not going to have control over how those assets are distributed. And it might be that you don't care. Like, I don't want to do this. I'm just going to walk away. This is not my job. And many times, especially if the estate is insolvent or the estate has tax debts or liens, sometimes a parent will name an adult child in their will as the executor, and the adult child doesn't want to do it. So you don't have to be an executor if you don't want to. Nobody can force you to be an executor, and you can decline. But if you decline being an executor, and you want the assets of that estate, then obviously you're not going to have control over how those assets are distributed if you decline to be the executor, if you are actually named as an executor in someone's will. You don't have to do it. Even if you're named as an executor, nobody can force you to be one. But just realize that if it's a situation where you actually do want assets from, for example, a family member's estate that they've passed, if you decline to be the executor, then the court is going to name someone else to do it. And then you got to basically bow out and you don't have any say anymore at that point. Example, Dominic is age 64 and unmarried. He has one 23-year-old daughter named Jacqueline. Dominic dies on November 3rd. Thankfully, Dominic had a will when he died. In the will, Jacqueline is named as the sole beneficiary and the executor of her late father's estate. Jacqueline seeks the help of a licensed tax professional as well as an attorney to help her navigate the probate process. So she hires people to help her, which is not uncommon. This would be typical, but she's the executor. She's the one ultimately making the final decisions and signing the tax returns. The attorney and the accountant will help Jacqueline file all of the necessary paperwork with the court as well as the IRS. Jacqueline will sign her late father's final personal income tax return as the executor. Her father's dead. He's not going to be signing anything anymore, including his own tax returns. But many times those tax returns have to be filed, and many times it will be multiple years of tax returns. Like for the year of death, that has to be filed, and many times the year before, and even the year before that, especially if the taxpayer has been ill for a very long time. Many times you'll be filing multiple years on behalf of a decedent. And if they are unfiled, then the executor is the one that's responsible for filing and signing all of them. Reporting executor fees. Now, I want you to understand that the executor usually gets paid. Executors usually gets paid. Most of the time, it's not considered business income. Most of the time, it's not. That's true even if you're an accountant. I've been approached to be an executor on more than one occasion. I'm a tax professional, obviously, but I'm not a professional executor. It's not something that I do on a regular basis, or even something that I would want to do on a regular basis. Usually, the executor gets paid, but it's not considered self-employment income, and you wouldn't report it on the Schedule C. For instance, if the executor is a friend or a family member of the deceased, then they're doing it because they are a friend or a family member. They're not in the business of being an executor. If this is a one-time deal and you're just doing it because you're related to the person who died. Executor fees are typically reported on the executor's individual Form 1040 as other income. So they would get like a 1099 from the estate. And it's an expense of the estate, the executor fees, but the executor typically will just report it as other income, not subject to self-employment tax. Now, if the executor is actually in the trade or business of being an executor, such as a self-employed estate tax attorney, the executor would report the fees received from the estate as self-employment income on Schedule C. There are professional executors out there, but most of the time, if you're like just doing it on behalf of a family member or a friend, you're named as an executor in their will, then it's just treated as other income. It's still taxable, but it's not subject to self-employment tax. It's not business income if you're just doing it as a favor to a family member or a friend. Now, let me give you an example. Example, Janice is an accountant who is best friends with Loretta. On June 1st, Loretta dies, leaving behind two sons, ages 18 and 22. So Loretta dies, and her sons are both adults, but they're very young adults, 18 and 22. Loretta's final will and testament names Janice, who is her best friend, as the executor of her estate. Janice agreed to be the executor as a favor to her friend. Janice is not in the trade or business of being an executor and has never been the executor of any other estate in the past. The fact that Janice is an accountant isn't really relevant here because she's not in the trade or business of being an executor. She's never done it before. And she's doing it only because Loretta was her best friend. So she's doing it as a favor to her best friend who has passed away. Janice will file Loretta's final tax returns as well as the tax return of the estate. And this would be Janice's job, not her sons. Her sons are the beneficiaries of the estate, but they're not the executors of the estate. The executor is Janice. She will also help distribute her deceased friend's assets to her beneficiaries, who are Loretta's two sons. Loretta's will stipulates that the executor of her estate is entitled to 2% of the income generated by the estate. Now, the executor generally gets paid, as I said before, and usually they will get paid a percentage of the income coming into the estate. Sometimes they can just get a flat cash amount too. Subscribe to PassKey Online for more great content about the enrolled agent exam. But generally, it's a percentage of the income that's generated by the estate. The executor fees paid to Janice would be reported on her individual Form 1040 as other income. The amounts would be subject to income tax, but not self-employment tax, because Janice is performing the duties of an executor only because she was a friend of the deceased. She doesn't have a profit motive in this. That's the IRS definition of a business, right? A business has to have a profit motive. And she's not in the business of doing this. She's only doing it this one time to help her friend. And she's an accountant, and she wouldn't report this on Schedule C. It wouldn't be considered accounting income. It's just treated as other income. Now, example number 2. John is a professional estate tax attorney. One of his longtime wealthy clients, Caroline, dies on January 3rd after a long battle with cancer. Caroline names her attorney, John, as the executor of her estate in her will. The sole beneficiary of Caroline's estate is her son, Benjamin, who is 17 and still a minor. Now, many times, especially if you have couples who are divorced, they'll have children together, right? And the children will go to live with the surviving parent. But especially if they're divorced, the surviving parent is not going to be the executor of the estate and also not going to be a beneficiary of the estate because that's the X. So the children many times will be minors. So the parent will name someone else, like a professional executor, as the executor in the will. The children will go to live with the other parent or some other family member, but that other family member won't be managing the estate. By the terms outlined in the will, John will manage the affairs of the estate until Benjamin turns 21. So John is the attorney, okay? And he's going to manage the affairs of the estate until Benjamin turns 21. By law, the executor has a right to charge a fee for managing an estate. Caroline's will stipulates that the executor of her estate is entitled to 5% of the income of the estate. The remaining income will go to provide Benjamin's ongoing support and pay for his schooling. As the attorney and the executor, John would report the income that he earns as an executor on his Schedule C, subject to self-employment tax. And he is self-employed, and he's an estate tax attorney, so this would be self-employment income to him. Presumably, he's doing this for multiple clients. So he is in the business of doing this, and he does have a profit motive in the activity. The executor's liability. Now, as I mentioned before, the executor is responsible for determining any estate tax liability before the estate's assets are distributed to beneficiaries. The tax liability for the estate attaches to the assets of the estate itself. The tax liability attaches to the assets of the estate. If the assets are distributed to the beneficiaries before the taxes are paid, the beneficiaries or the executor may be held liable for the tax debt up to the value of the assets distributed. A personal representative or an executor of an estate cannot be held liable if an insolvent estate does not have enough assets to cover any of the income taxes due or any debts. Yeah, the IRS cannot get blood out of a turnip. If the taxpayer dies and they're insolvent, they don't have the assets to cover their debts, then that's it. The IRS can't go after other family members for the taxpayer's own debts. But the problem is that what taxpayers don't understand is many times taxpayers will die with assets that could satisfy the tax debt. Like, okay, so a taxpayer dies and they owe $10,000 to the IRS, and then there's no money, right? There's no money. But he owned a house and he owned cars, and the house has equity and the cars are worth something. So the tax liability for the estate attaches to those assets, to the assets of the decedent. And many times what will happen is the kids will come in, let's say dad dies or mom dies, and she owned a house and cars and stuff, and she had money in the bank. They'll come in and they'll sell the house, they'll sell the cars, or they'll take the cars. They'll, get money out of the bank. They'll sell the investments, and they won't take care of the tax liability first. That happens a lot. So if an estate is actually insolvent, then the IRS can't go after the beneficiaries or the executor or the heirs if the estate is insolvent. But many times the estate is not insolvent. The estate, has houses, it has cars. The taxpayer will die with those types of assets. And the kids will come in and they'll try to sell all of those assets so they can get the money. And they won't take care of the tax liabilities first. Tax liability has to be taken care of first. Okay, and then what's left, if there is anything left, then that can be distributed. Those assets or that money can be distributed to the beneficiaries, but not before. Okay, the executor must be sure that any income taxes are paid before any assets are distributed to the beneficiaries of the estate. Otherwise, the executor might be held personally liable for the tax debt. And many times the executors, the other beneficiaries will wear them down. Like, oh, my mom died a year ago. Why is this taking so long? How come we don't have money? How come you don't give me money? And the executor will just capitulate, and they'll start distributing the assets to the beneficiaries because they won't shut up about it. They're like, I want my money. I want my mom's money. She promised me this money. And they won't take care of the tax returns or the tax debt before they distribute those assets. But that's part of the executor's job, is to make sure all of the tax liability and the estate tax liability, if it is a wealthy person, is taken care of first. Then the assets can be distributed to the beneficiaries, but not before. Otherwise, the executor can be on the hook for that debt. Example, Silas, age 27, was named the executor of his late mother's estate. So his mom died, and he's named the executor. He's 27. Silas has two younger sisters, Rebecca and Sasha, who are both under the age of 18 and still minors. All of the siblings are equal beneficiaries of the estate, but since Silas is the only legal adult, he's the only one that's over the age of 18, he is named the executor of his mother's estate by the probate court. Silas distributes a large amount of stock and cash to himself and both of his sisters before he has had his mother's assets properly appraised. And many times this will happen. He wants the money, so he's selling stock and distributing cash to himself before he had the assets properly appraised. He's not getting any kind of advice, and he should. After the appraisal is done, Silas realizes that his mother's estate had a filing requirement and an estate tax liability. Since Silas distributed assets to the beneficiaries before determining the correct amount of tax due, he may be held personally liable for paying the estate tax himself. So he could be on the hook for this, any estate tax that was owed by his mother's estate, because he did this the wrong way. He distributed assets before the estate tax was determined, so this is bad. You don't want to be in this kind of a situation. Subscribe to PassKey Online for more great content about the Enrolled Agent exam.